Welcome to the latest episode of Gowling WLG's Employment Essentials podcast, where we discuss the latest developments and challenges affecting employment law in the UK.
Hello and welcome to our TUPE Club podcast. This is the second of our podcasts for TUPE Tuesday mini-series, and we've put this together to bring you up to speed on the important TUPE news for this year in TUPE Club. There are 4 podcasts in this series. The first one was last Tuesday, and a new one will be released every Tuesday until the 6th of December. For the first 3 podcasts, we're looking at a key appeal level TUPE case. And then in the final podcast, we're going to look at what developments might be coming down the tracks in 2023. I'm Siobhan Bishop, a Principal Associate in the Employment, Labour and Equalities team at Gowling WLG. And in this week's TUPE Tuesday, I'll be talking about a case on service provision change and whether the activities pre and post transfer were fundamentally the same. So this week's case is Tuitt and London Borough of Richmond, Thames. In this case, the Employment Appeal Tribunal confirmed that the CCTV related activities pre and post transfer were not fundamentally the same, and there was no service provision change under TUPE and the relevant employee did not transfer. So I think it's helpful to have a quick reminder of the main TUPE issues which are relevant here. So under TUPE, there are 2 types of transfer, a business transfer and a service provision change. For there to be a service provision change, the activities carried out after the transfer must be fundamentally the same as those carried out before the transfer. The 2014 amendments to TUPE added a provision that references to the service provision changes, which are set out in Regulation 3(1)(b), to activities being carried out instead by another person, including the client if it's an insourcing, are the activities which are fundamentally the same as the activities carried out by the person who has ceased to carry them out. And the statutory test and case law shows that the key issue is firstly to identify the activity undertaken and whether it has changed after the alleged transfer, and if so, by how much. The previous case law confirms that those activities need not be identical. It will be sufficient that they are fundamentally or essentially the same as those carried out by the alleged transferor. And this was confirmed by the EAT in the Metropolitan Resources Limited and Churchill Dulwich case in 2009. In this case, the EAT upheld the Employment Tribunal's finding that the claimant's employment did not transfer under TUPE because the activities carried out before and after the alleged transfer were not fundamentally the same. And it said that the explanation or reasons behind the change are not directly relevant unless they show some deliberate engineering to avoid TUPE. In this case, the activity was fundamentally different, so it didn't matter why that was the case or whether it arose from staff availability or staff's capacity to take on those additional duties or for any other reasons. Now, the question as to whether the activities are fundamentally the same is one of fact and degree for the tribunal's assessment. And so it's really helpful to have examples to consider when looking at a particular situation that you might be dealing with. But given the facts and circumstances are always relevant, let's have a look in detail at the background. Ms. Tuitt was employed by Broadland as a CCTV monitoring operator from 2005 until 30th of June 2018. Now, from 2005 to 2018, the local authority outsourced its CCTV monitoring to Broadland. The CCTV operatives working on the CCTV proactively monitored 12 screens for 12 hours over the period of a night, and they reported any suspicious behaviour to the police. And they also responded to safety-related calls from the police, from businesses and from the public. In 2018, Broadland gave notice to the local authority to end the contract. And when the contract ended, the local authority, which was facing mounting pressures to make budget cuts, chose to divert the CCTV funding, and the local authority no longer employed full-time CCTV operatives. So what they did instead was to provide some CCTV services, but those future CCTV monitoring would need to be done by the local authority's care line operative, who was on duty in any event, and who also happened to work out of the CCTV monitoring room. However, the care line work was to take priority over any CCTV monitoring. So in reality, on any given shift, the care line operator on duty was already overloaded with time-consuming calls in relation to vulnerable residents. The care line work would routinely take up to 95% of the on-duty operative's time, and so they would only be able to perform minimal CCTV monitoring. The care line staff could only provide reactive support as a result, and even then, the majority of calls went unanswered. And as there was only one care line operator who worked each night, there was vastly less CCTV monitoring performed overall than previously, and at all times, the care line work took priority. So any monitoring which the staff member managed to do was very limited and reactive only. However, Miss Tuitt claimed that the local authority's care line staff, who she had previously worked alongside in the control room and who now undertook the CCTV monitoring, were providing essentially the same activities that were carried out after the alleged transfer as she had undertaken beforehand. The local authority argued that there was no service provision change because the activities carried out on or after the transfer were fundamentally different. So what did the Employment Tribunal say at first instance? As a high level, the local authority was continuing to provide CCTV monitoring services of sorts, but that was the extent of any similarity in the activities. The monitoring which took place before by Broadland was fundamentally different, and the local authority no longer engaged a company to provide CCTV operatives. And it wasn't only the amount of monitoring which was significantly reduced, but the type of monitoring would change considerably as well. It was important that there was no proactive support, which previously had been a large part of the role. The CCTV cameras were not checked, and there was no routine surveillance of areas in which the cameras were situated. Calls from the police and public were unanswered, and the local authority could no longer routinely provide this service. So proactive support was really a key part of Miss Tuitt's role, and that had effectively disappeared overnight. However, it also said that there was no deliberate action on the local authority's part not to fund the service to prevent a TUPE situation applying. It was simply that the demand on the local authority's budget meant that the money for the service unfortunately disappeared to pay for something else. There had been a genuine attempt to cut costs across the board in light of budget constraints which the local authority faced. Ms. Tuitt appealed to the Employment Appeal Tribunal and claimed that the Employment Tribunal had been wrong to conclude that the activities pre and post transfer were not fundamentally the same. So turning to the decision at the Employment Appeal Tribunal, Ms. Tuitt had claimed a number of things at this level, including that the tribunal's approach to the categorisation and identification of the activities and the comparison between the activities before and after the change of providers was wrong and too pedantic. In particular, she claimed the fact that the care line staff performed additional duties or functions did not prevent there being a service provision change. So the fact that the employee availability was limited was irrelevant and should not have been taken into account by the Employment Tribunal. The activity itself was still there to be done. She also appealed on the grounds that there had been an error of law or perversity in the tribunal's conclusion that there was no deliberate action on the part of the local authority to avoid TUPE from applying. So the EAT helpfully reviewed the case law and noted some key points, which I think it's worth mentioning. The case law reiterates that whether the services are fundamentally the same is a question of fact and degree. In considering whether the activities undertaken after the alleged transfer are fundamentally the same as those carried out before it, minor differences between the two will not prevent a service provision change. On the other hand, the activities should not be defined at such a level of generality that they do not really describe the specific activities at all. So, on the other hand to that, the definition should be holistic. It should have regard to the evidence in the round and avoid being too narrow and focused and deciding matters in a pedantic way. if there was an excessively detailed definition of activities, that could risk defeating the purposes of the service provision change provisions. So if there was an addition of some duties or function, this is unlikely to prevent there being a service provision change, unless that addition meant that they were no longer essentially the same. However, it's not a question of simply asking whether the activities carried the same label, and that label continued after the alleged transfer. As we know, in many areas, labels and job titles, for example, do not always reflect the reality of what is being done on the ground. The tribunal must make a factual assessment and consider both the character and type of activities which were carried out, but also the quantity of activities. A substantial change in the amount of a particular activity that the client requires could show that post-transfer activity was not the same as it was pre-transfer. And where the volume of work undergoes a substantial reduction, that may lead to a conclusion that the activities being carried out are not essentially the same as before, even if the same categories of work did apply. The Employment Appeal Tribunal upheld the tribunal's findings in this case, and that there was no service provision change from Broadland back to the local authority, because it said the activities pre and post transfer in this case were fundamentally different. And we've touched on a number of those reasons, but they were essentially fundamentally different for quite a few reasons, including Broadland had provided the full-time CCTV operators between the hours of 6 p.m. and 6 a.m, and their entire role was to proactively monitor the CCTV footage on a 12 control room screen and to respond to safety-related calls from a variety of sources: police, pubs, clubs, high street stores, and there was a great deal of proactive monitoring. After the alleged transfer date, only monitoring on the cameras was done by one single member of Careline staff who was on duty, and it was merely in addition to their main Careline duties. The Careline duties of the existing staff were not merely something additional to the CCTV duties, which had existed beforehand. The Careline duties were at the heart of the activity which was being undertaken by the Careline employees, and they were already overloaded with those duties. And so the extent that they were able to perform any additional CCTV monitoring was very minimal. Any CCTV monitoring that they did perform was only reactive, and even then, they couldn't get to many of the calls. The local authority's Careline staff were not performing the majority of the duties carried out by Broadland. So not only did the amount of monitoring undertaken reduce very considerably, but also the type of monitoring that was undertaken changed considerably, in particular this proactive monitoring which had disappeared. And that had played a huge part of the claimant's role and effectively vanished. The Employment Tribunal have found that the local authority's Careline staff were not performing the majority of the duties carried out by Broadland, and it was far from the case that the Careline duties were simply additional. As such, the duties pre and post transfer were fundamentally different. There was no service provision change, and the employment did not transfer under TUPE to the local authority. The Employment Appeal Tribunal also rejected her claims that the change in activities had been engineered by the local authority to avoid TUPE applying. It said there was simply no evidence that the decision not to employ full-time CCTV operatives was driven by anything other than budgetary pressures which were faced by the local authority. There was no deliberate action on the part of the local authority to avoid TUPE applying to her employment. In fact, Broadland was the party who had terminated the contract, and the local authority needed to make budget cuts. And there had been a genuine attempt to cut across the board of the local authority in light of budget constraints. So looking at reasons behind any change are only relevant if they indicate a deliberate engineering to avoid the consequences of TUPE. Now, Ms. Tuitt did try to appeal to the Court of Appeal, but her application for permission to appeal was refused on the papers in October 2022. So in conclusion, it's really helpful to look at this case for guidance on factors which can be considered when determining whether pre and post transfer activities are fundamentally the same. Clearly, each case will be different, but this is a useful example of where an activity was no longer fundamentally the same. It's also an example of the importance of drilling down and understanding what the activities actually entail, especially if they could appear to be the same on the surface. So just because the label CCTV monitoring was added to the care line operative's list of duties, that didn't necessarily mean that the CCTV monitoring activity carried out before and after the transfer was fundamentally the same. While it's true that the activities don't need to be identical, they do still need to be fundamentally the same. And that's a question of fact and degree for the tribunal to assess and for the parties to attempt to assess before deciding whether TUPE applies. So as was the case here, there was a significant change from this full, predominantly proactive monitoring service to very limited and minimal reactive service, meaning it wasn't fundamentally the same activity. So Ms. Tuitt's employment did not transfer to the local authority, and she did not succeed in claiming that there was service provision change. Thank you for joining us today, and please do join us again next week for our third instalment of TUPE Tuesday podcast. If you want to catch up on last week's TUPE Tuesday podcast, that's still available on our website, and that covers the employment appeal case of Clark and Middleton, covering TUPE information and consultation. Next week, we'll be looking at the issue of providing share incentive plans post-transfer, even where there is no contractual right to participate in the scheme. And of course, in the meantime, if you have any questions, please do contact one of the team. Thank you.
Thanks for joining Gowling WLG for this podcast. If you enjoyed this episode, be sure to check out our website at gowlingwlg.com for more useful insights and resources. And don't forget to subscribe to ensure you join us for our next episode.